Very short introduction for the next two speakers. Aaron Goerlich and Jason Maddux. Aaron Goerlich has represented a full range of aviation clients from manufacturers, airlines, foreign domestic operators, corporate business, aircraft operators. He's heavily involved in MBAA, serves with me on the Domestic Ops Committee. He's also a member of RIAG, which is it's like AFS 830. I have no idea what that actually stands for, but it's a bunch of lawyers that get together and form a committee over at the NBAA. He's also a pilot and airplane owner. I think you'll hear a little bit more about that later on. Jason Maddux has worked with Aaron since 2005 and specializes in regulatory and contractual matters and enforcement proceedings. He is a Tampa Bay fan, I found out yesterday. I was out crashing my quadcopter outside during lunch, and the first two people that show up to inquire what's going on just happen to be the lawyers. And they asked me, is this a commercial operation? Which it wasn't, of course. So, Aaron, welcome. Jason, welcome to CBAS 2015.
Okay, can everybody hear? Okay, good. Okay, thank you, Al. Welcome back, everybody. First of all, I want to thank Al and Reynolds Jet for organizing this. I think it's a terrific function, and I hope everybody's getting something good out of it, and we'll try to add to that. Al's already introduced the two of us, so I won't go through any of those details again. I do want to extend a bit of an apology. I'm afraid we don't have any F-16 videos. Our stuff is going to be a little on the dry side. But if anyone would like to get out your Sharpie and draw a picture of operational control, I'll promise to put it on the projector here so we can all see. That would be great. Okay. This is just an outline of our presentation, and I think we should have some time at the end, so if anybody has questions, we can take them then or later on today. But, the first thing we're going to talk about, or that I'm going to talk about, is what is operational control? What is this concept? And then I'm going to discuss why it's significant, particularly from the regulatory and legal perspective, and also from a practical perspective. And then Jason's going to take over, and he's going to go through some operational control scenarios, which are going to get a little more into the nitty-gritty. And obviously, we've tried to key this to the type of operations that we understand you folks are involved in, and that would include Part 91 and Part 135. And then at the end, we'll circle back with some practical examples to discuss. Just as an additional prefatory observation, many of you may recall that 10 years ago, it's been 10 years now, there was an accident at Teterboro Airport where a Challenger aircraft was blasting down the runway, and the airplane would not rotate. It never got airborne. And it careened through a fence and across a highway and wound up across the street up against a building heavily damaged. And fortunately, there were no fatalities. There were some injuries. They weren't too serious for the most part. But it was something that got the attention of the FAA in a big way, as well as the NTSB. And the investigation that ensued determined that this airplane was operating under what I would refer to as a rent-a-certificate operation. That is, it was listed on the Part 135 op specs of a commercial air taxi of a 135 operator, but it was being operated by an entirely different entity. And that entity was also the owner of the aircraft. And that other entity which was not a 135 certificate holder, not a licensed air carrier, was selling charter flights on this airplane. So that's what I refer to as rent a certificate, because the 135 operator whose certificate the aircraft was listed on had no control over it, no operational control over it. As a matter of fact, when the accident occurred, they didn't even know the airplane was flying. Well, obviously that's not how commercial aviation in any form is supposed to work. And as a result of that investigation, the FAA, and with good reason, became very concerned about operational control, particularly in the 135 industry. It's not so much of an issue. In fact, it's not much of an issue if you're Delta or American or Southwest. Everybody understands who has operational control. But in the 135 industry, it's not always so clear. And I think the FAA itself wasn't particularly clear. I think as part of the investigation of this accident, the FAA got an education as to how common it is in the 135 industry for XYZ Corporation or XYZ high net worth individual to own an aircraft, a sophisticated aircraft like a Challenger or a Lear or Gulfstream, what have you. But that airplane is turned over to a management company, and the management company might be a 135 certificate holder, frequently it is, and it may not be, but at any rate, that owner is essentially hiring the expertise needed to manage the aircraft properly and see that it's operated safely and properly. And when the management company is also a 135 operator, operational control will change, depending whether it's being flown on a charter flight for a third party or whether it's operating for the owner. So you get this migration concept, and Jason's going to talk about that in greater detail. And that was something that, at least from where I sit, the FAA didn't really have a full understanding of. But as a result of this investigation, they developed an understanding of it, and that led to some significant changes. It led to a lot of special emphasis inspections. It led to very detailed guidance that the FAA issued in writing. It led to a massive rewrite and increase in the scope of OpSpec paragraph A008, which I'm going to talk about a little later, which is the operational control provision in a 135 operator's OpSpecs. So let's start then with the question of what is operational control? What do those words mean? And I think the best starting point is the FAA definitional guidance, which you will find right in the FARs, section 1.1. Operational control with respect to a flight means the exercise of authority over initiating, conducting, or terminating a flight. That's how the FAA defines that term. And they define the word operate, as you can see. Operate with respect to aircraft means use, cause to use, or authorize to use aircraft for the purpose of air navigation, including the piloting of aircraft. Notice the word including, with or without the right of legal control. So those are both broadly worded definitions, and they are broadly worded by design. And I think what's really key here is that this concept of operational control involves much more than manipulating the controls on an airplane. It has to do with the exercise of authority over the operation of an aircraft. That is the key to it. So in the definitions, the FAA is casting its net widely. It's quite possible that more than one entity or more than one person could be deemed to have operational control of the same flight under the legal definitions that they use. So the question becomes then, what entity or what individual, as a factual matter, exercises the authority to initiate, conduct, and terminate a flight? Now, while, as I mentioned, this question has significant legal and regulatory implications, and as I also mentioned, determining who has operational control is a fact-based totality of circumstances type of analysis, which means all kinds of factors come into play. Based on published FAA guidance, we can glean that there are really three fundamental questions that determine who has operational control of a given flight. First question, who makes the decision to assign flight crew members an aircraft for a flight? Secondly, who makes the decision to initiate, conduct, and terminate the flight? And lastly, for whom do the pilots work as direct employees or alternatively as agents? Now, focusing for a moment on the first question, if someone is assigning an aircraft to a particular flight, that would indicate that that individual or that company has a possessory interest in that aircraft. They have a right, legal right, to determine how it's used, where it goes, and so on. And indeed, having legal possession, a possessory interest in an aircraft, is one of the elements of operational control that the FAA has recognized. When we talk about making a decision to initiate, conduct, terminate, well, that clearly is an exercise of authority. As I mentioned, that's the key. Somebody makes the decision, this flight's not going because the weather at the destination, forecast weather for the time of arrival is below minimums and we're not going. Now, that's clearly an exercise of authority. And as far as the pilots, I think that's pretty much an exercise of authority as well. If a pilot answers to a particular aircraft owner, or if a pilot answers to a particular 135 operator, then it's pretty clear what the line of authority is. And the corollary to that, of course, is that the pilot needs to understand who he or she is answering to in the particular circumstances. And as we'll discuss a little later on, that can vary depending who has operational control. Common thread, again, exercise of authority. Now, the answer to the three questions should be the same. Okay? So the answer to the questions might be Reynolds jet, for example. That they are making the assigning the aircraft, assigning the crew, making the determination whether the flight should be initiated, employing the crew. That's operational control for a 135 operation. Operational control in this entire area is so significant to the FAA, in the 135 context particularly, that they have a set of requirement for 135 operators to have a system of complete, effective, and sustainable operational control. In other words, a system to prevent against dilution of operational control. And I would suggest to those of you who are Part 91 operators that it is advisable for a 91 operator to have a formalized system of operational control as well. The 5 items listed there, crew member requirements, aircraft requirements, and so forth, are among the elements of the system that the FAA requires. And this is all memorialized in that operation specification, OPSPEC A008, that I mentioned earlier. And these items are among the, quote, essential elements of operational control that must be included or described in that system. The crew member requirements, crew has to be direct employees or agents throughout every aspect of the 135 operation, not just flying the airplane, but pre-flight and post-flight activities. Have to be properly trained and qualified and so forth. The aircraft, the operator has to have exclusive possession of the aircraft at the time of the operation. It does not mean exclusive possession 24/7, 365. It means exclusive possession at the time of the operation in question. Business names is an issue that's come up, and the restriction there is that if the operator, the 135 certificate holder, is using a business name, a DBA, doing business as name, it's got to be not misleading. It can't create the impression that some other entity has operational control. Aircraft operation agreements refers to the delineation of responsibility between an aircraft owner who, for example, would put the airplane with the 135 operator for management services, delineation of responsibility operationally between the owner and the 135 certificate holder. And frequently there's an issue that arises regarding pilots, and we'll touch on that later. If the pilot is an employee, a W-2 employee of the 135 certificate holder, and the aircraft is going to operate on a Part 91 flight whereby the owner of the airplane has operational control, can that pilot operate as an agent for that owner? The answer is yes, subject to meeting certain requirements. And the reverse is true. The pilot could be an employee, a W-2 employee of the aircraft owner, but also fly for the 135 certificate holder, subject to meeting certain requirements. That was a big issue with the FAA following that Teterboro accident as to whether they were going to allow this, and they finally saw their way clear to do so. The information requirements relate primarily to communications with the pilot in command, and so there's never any lack of clarity about, is this a 135 flight or is this a 91 flight? And bear in mind that it is possible for a 135 operator to fly some 91 flights. That would be the situation where there is no revenue traffic of any kind on the airplane, no passengers, no cargo, nothing. Okay, so a positioning flight, a maintenance test flight, that sort of thing would be a 91 flight or a 135 certificate holder. Okay, let's talk now about the significance of this whole issue. And I'll start with the most important consideration, and that is it's safer. Now, and you guys are much more expert than I am on this point, but to me, where you have clear lines of authority and clear delineation and everybody's on the same page, you will have a safer operation. If there's some question about who's running the show, then that will degrade safety. So I think that is the most important thing, a systematized approach with clear lines of responsibility and accountability. That will be a haphazard approach every time, and that's true whether it's a 91 operation, a 135, any operation. Okay. Legal liability is typically tied to operational control as well, which is to say the entity with operational control will normally have liability in the event of an accident or incident. Okay? So given that the entity with operational control is going to be responsible, or at least presumptively responsible if there is an accident, this becomes very important from the standpoint of insurance coverage, because you've got to make sure that the insurance coverage is adequate, that the limits are sufficient to protect whoever may be involved. And this can be an issue, particularly with where there's an individual owner who has operational control. It's a high net worth person, and they've got to be appropriately protected. By the same token, bear in mind that, insurance companies are not, they're frequently willing, in a worst case scenario, to consider whether the coverage is really in force. And any insurance policy will have certain warranties, if you will, compliance with FARs, commercial versus non-commercial operations, that sort of thing. that could bear on coverage. So if you have, the worst case scenario is, for example, you've got an insurance policy that applies to non-commercial operations. And due to an operational control problem after an accident or incident, you get an FAA investigation or NTSB investigation, what have you, that determines this was actually an unauthorized commercial operation. But your insurance policy was non-commercial. Are you now going to be in a position where your insurance company, your insurance coverage is jeopardized or even invalidated? Obviously, no one wants to go there. So that's a very persuasive reason, in my view, to be very cautious about operational control and make sure that this is all properly delineated and that the rules are followed so that in the event the worst happens, you don't have to worry about insurance protection. And the last element of the significance considerations is regulatory responsibility and accountability. Without a doubt, regulatory responsibility runs with operational control. So whoever has operational control of the flight is going to be responsible to the FAA in the event of any violations or deviations or what have you. So this is another reason that you don't want a lack of clarity as to who has operational control. Let me just read you a very brief little excerpt from OpSpec A008, the one that I mentioned. Quote, the certificate holder retains all responsibility for the operational control of aircraft operations and thus the safety of each flight conducted under this certificate and operation specification, including the actions or inactions of all direct employees and agents of the certificate holder. This responsibility is not transferable to any other person or entity. The certificate holder's responsibility for operational control supersedes any agreement, contract, understanding, or arrangement, oral or written, express or implied, between any persons or entities. So the FAA is real serious about this. And they want this clear delineation that I'm talking about. And while that is addressed to the 135 industry, that's a Part 135 OpSpec that everybody has, every 135 operator. One could substitute Part 91 operator for certificate holder in that section that I just read, and even though, you know, this isn't something that's imposed particularly by the FAA, it would still be an accurate reflection of how things work. So under that scenario, the Part 91 operator retains all responsibility for operational control and the safety of each flight, et cetera, et cetera. So as a Part 91 operator, you're carrying that same level of responsibility and accountability for regulatory compliance. This comes up as well in the special authorization area, FAA letters of authorization, or LOAs as they're called. For example, LOA to operate in RVSM airspace. This is an area where, fortunately, in the past year or two, there's been a great deal of improvement on the FAA side, in my opinion, because you have an airplane, 135 operator may have operational control or will have operational control of chartered flights. The owner, aircraft owner, may maintain operational control of flights that are operated for its business purposes, for example. Want to fly in RVSM airspace, you have to have a letter of authorization. The letter of authorization necessarily should be issued to the entity with operational control. That means for this particular airplane, there would be two letters of authorization, one to the 135 operator, one to the Part 91 operator. For a long time, the FAA was having a real problem with that. And then finally, largely as a result of the efforts of an NBAA committee, the FAA has modified their procedures and gotten the word out. So now multiple LAs for a single tail number are available and have been issued on numerous occasions. So that problem has been solved. Internationally, something to consider. If it's a commercial operation, 135 operation, it's often subject to a much more comprehensive scheme of regulation and limitations on what can and can't be done in foreign countries versus a 91. So again, maybe that's something you plan for. In some instances, some owners might prefer to fly 135, not have operational control as a general rule, but when they're traveling internationally, maybe they do want to have operational control to avoid these limitations that are found in foreign countries. That can be done, but it has to be properly set up, properly documented, and most importantly, properly implemented. Tax considerations, this has to do, again, primarily with the federal excise tax. But there again, there's a distinction. The IRS uses the term possession, command, and control. That's equivalent to operational control. As a matter of fact, you think about it, possession of the aircraft, command of the aircraft, control of the aircraft. That's not a bad summary of what operational control is for FAA purposes. So if that's a commercial operator, then the 7.5% FET applies. If it's a Part 91 operation, with a few exceptions, that does not apply, although the higher level of fuel tax applies. So that's getting down in the weeds. At this point, I'm going to sit down, and Jason's going to take over and talk about his portion of it.
Thank you. Good afternoon, everyone. Hopefully you're still awake. Post-lunch time slot is always the most difficult, and we don't have any, not only do we not have Thunderbird slides, or we don't have any movie or TV show scenes like Al's approach. And if we're invited back, we're going to have to work on that, Al. But my thanks also to Reynolds and Al for having us out, and hopefully this will be educational, if not exciting. So we're going to run through the foremost common operational control scenarios, how operations can be structured. First, there are two subcategories of the Part 91 internal flight department. We have the owner-flown operations where, say I own a 172, I have a private certificate, and I go out and fly in my plane. I'm the owner, but I'm also the operator. The way the FAA defines it is the person with a possessory interest also manipulates the controls either directly as I'm doing, or if I step up and decide to buy a CJ3, for example, and I want a contract pilot, I hire that pilot, and I'm not manipulating the controls directly, but I'm manipulating them indirectly through this contract pilot, but I still have operational control. Of course, in that scenario, this is going to be a common theme throughout the rest of the presentation, is when you have contract pilots, a very important consideration is to have some form of crew agency agreement with that pilot, again, delineating who has operational control. The next example is the corporate operations, which I'm sure everyone is familiar here. This is where all the flight and maintenance and dispatch, for lack of a better word, but 91 and 135 cents, are all run in-house with a company that owns the aircraft, or another possessory interest, say a lease of the aircraft. Pilots and mechanics, everybody's employed internally for the most part, though again, contract arrangements could be used for both of those types of services, pilots and mechanics. Of course, this brings up the flight department company dilemma, or more threateningly, the flight department company trap, as it's sometimes referred to. And I know NBAA has harped on this, and FAA has interpretations on this going back decades, but it still seems to come up quite commonly, and I'm sure many of you are familiar with it as well, so we'll go through it quickly. And that was where essentially a single-purpose LLC has a possessory interest in the aircraft, whether it's owned or leased, and that single-purpose LLC or other company operates the aircraft, carrying passengers or property. Well, the problem is that single-purpose LLC has one purpose, and that's carrying passengers and property, and it has to receive compensation in some form, or it could not actually operate that aircraft, whether it's receiving direct it charges another company or an individual directly for those flights, or if it receives capital contributions from, say, its principals or its parent company. So again, that's a single-purpose company whose only operation is air transportation because it's carrying passengers and property for compensation. And FAA takes the view that that's a commercial operation and it requires commercial license from FAA. The problem we always are presented with from numerous clients is, well, our corporate attorney told us to structure it this way because for liability reasons, you're insulated a little more by having the airplane and the operation placed in this separate entity. And we have said, well, that's great from a liability standpoint, but it's not going to pass muster at FAA. The operation of the aircraft needs to be incidental to the company's other business. If the company's only other business is flying the plane, then that's not incidental. The companies have some other substantial business. It can't just be token business either. It needs to be substantial business so that the operation of the aircraft is not a major enterprise in itself for that company. One solution we often see to the flight department company dilemma is the single-purpose LLC leases, dry leases, meaning without any crew, dry leases the aircraft to an affiliate, and the affiliate, which has substantial other business, operates the aircraft, carrying its usually company officials, officers, directors, employees, and guests, and that solves the dilemma. Now, that might shift since this other company, the parent company, which has other business, is then taking on operational control. The liability is shifted, but basically that's what needs to be done to satisfy the FAA at this point. These dry leases, again without crew, can be exclusive or non-exclusive. You can have multiple dry leases if you want to, several individuals to several companies. Really the intent of the dry lease is to transfer operational control to the lessee, whoever you're leasing it to, whereas the lessee will provide its own crew, whether again directly or indirectly. And really that should be the intent of the dry lease. That should be specifically stated in the dry lease. And as part of FAA's truth in leasing requirements, one of which there's certain statements you have to include in any lease, one of which is who will have operational control, the signature of who will have that responsibility for operational control. The next scenario is when you bring instead of a dry lease, there is a wet lease, the other form of the most common leases, where you actually lessor provides aircraft and at least one crew member. It could be pilots, it could be even a flight attendant, but it's one crew member for that aircraft, and it becomes a dry lease. The difference here is in a wet lease, the lessor retains operational control. The intent is not to shift operational control to the lessee. The examples up there, a couple of which are true leases that at least the FAA considers them leases, but all of them are examples of an ability for a private operator to receive limited compensation for what essentially is air transportation, providing carrying passengers or property for compensation or hire. The FAA recognizes several exceptions to its overall requirement to be licensed if you're operating for compensation or hire. These examples are found in 91501B, a very popular number in the FARs. They are applicable only to the operation of large aircraft, except there is the NBAA standing exemption that if you're a member of NBAA, these exceptions can also apply to operation of your small aircraft. The first example, time-sharing agreements. These are, again, it is a wet lease. It's the providing of aircraft and crew to another person. So you can carry the passenger and property of this other person, which can be a company or an individual. But the only charges that you can recover, you, the lessor, the operator, the wet lease, you are remaining the operator and operational control. And the charges you can receive in exchange are essentially twice the cost of fuel, with a couple other incidental charges thrown in that you can recover. And the next one, interchange agreements. Again, these are all specified in the regulations themselves. Interchange agreement is the lease of the aircraft. Though it's not specified in the agreement, is implied, and FAA has confirmed that this is a wet lease. It's really the provision of the aircraft and at least one crew member to another person in exchange for equal time on that other person's aircraft. So it's essentially a barter arrangement. I agree to fly you around for 5 hours while on my plane, and you agree to fly me around on your plane for 5 hours. There is a slight caveat in that if there is a difference in the cost of owning and operating those two aircraft, you make a charge for that difference. So if one aircraft is a 650 and another is a Aviation Jet 3 again, there will be a cost difference in between operating, maintaining, and owning those two aircraft, and you can charge that difference. But again, it's a wet lease. Operator control remains with the wet lessor, the person who has possession of the aircraft, and provides the crew. Joint ownership arrangements. This is where several joint owners of an aircraft, and they have to be registered joint owners, registered at the FAA Civil Aircraft Registry, own an aircraft, but only one of those joint owners employs the pilots, the crew for that. And that's fine. I don't know if the FAA technically considers that a wet lease, but it has all the nuances of a wet lease, the indicia, and the other owners, the ones not providing the crew, pay their share of the expenses then for being able to use that aircraft, and those expenses are allowed to be set out in the joint ownership agreement. Parent subsidiary operations. This is, you've probably heard this term too, 91501B5. It's very popular. It's where a parent or a subsidiary, either one, can carry the official's employees, guests, property, or those are the categories of the other. So if the parent can do that, carry those of the sub, or the sub can do that and carry those of the parent. But provided that transportation is within the scope of and incidental to the company's business, the company that's operating the aircraft. The caveat is if they're carrying guests of the other company, the sub, if the parent's operating, then no charge can be made for carrying those guests unless the operation is also within the scope of and incidental to that other company whose guests are being transported. Now, the charge that's allowed, that the operator is allowed to recover in that instance, is basically the fully allocated cost, the cost of owning, operating, maintaining the aircraft for those flights. A question we often get asked is, well, how do I know? I do my budget on a yearly basis, and I don't know my actual cost until the end of the year. So how do I allocate that? And there's no real good guidance on that, unfortunately. Some companies decide to charge their best guess. Some wait till the end of the year and actually determine their specific costs, and then they go back and charge their sub or their parent those specific costs per flight hour. Again, we don't know of any specific guidance on point, which is the better approach. The last exception to the licensing requirement that we're going through is the FAA interpretation, which we refer to as the Nichols opinion, granted to an MBAA executive who was the author of the opinion request. And it's basically a reinterpretation of the rule that allows for the parent subsidiary operations exception. And that is where in a corporate environment, there are some executives to that company who are so essential to the company that when they are traveling on personal business, or I should say business, on personal travel, but in the corporate aircraft, and if they're so essential that they can be recalled from their personal travel, then the company is allowed to be reimbursed by that executive, basically the same cost that could be recovered in the parent subsidiary operations, the fully allocated costs for those flights. Now, there are some nuances to this, some hoops that have to be jumped through. First, not all executives are eligible for this exception. There's a concept under IRS rules of individuals that are very important to the company, but the FAA has decided not to adopt those. It's basically, again, the company itself has to decide that these executives are so essential to their operations that they can be recalled. So there should be some kind of written formal determination by the company, maybe a board of directors resolution that says this, but the FAA has made it clear that they don't expect that's every executive at the company, VP level and up. They really intend this to be a very few top, maybe the CEO, maybe the COO, CFO at the most. Again, as for personal travel, they can be recalled. FAA has said they don't expect that executive, even if he is deemed so essential, that he can be recalled, he or she can be recalled from any type of their personal travel. So, for example, if the executive is going for open heart surgery, he can be recalled for that if he's on the operating table. If he's going for, say, his daughter's wedding, probably can't be recalled from that. So there are some exceptions. The way to make sure you're falling within the parameters of this rule is to keep very detailed records of these personal flights, both on the cost side, so you know what can be reimbursed, but also on the purpose of the trip. So you can document that the executive is indeed traveling on a type of trip where he or she can be recalled from, and keep those records should the FAA ever come knocking. The next operational control scenario is where the Part 91 operator decides to outsource one or more of its operational control functions, not the responsibilities, but the functions to an outside provider. It could be more of a turnkey operation to a management company, or it could be just, say, outsourcing the maintenance or obtaining contract pilots from a crew resource provider. Again, even though some of these functions are being outsourced, the operational control remains with the Part 91 operator. The key to this arrangement is the management agreement that you have. If it's a turnkey management agreement or something less all-inclusive, that agreement needs to specify exactly which functions are being delegated, but also confirm that operational control remains with the possessor, the owner, or lessee of the aircraft, and also that operator retains legal and regulatory liability. This is something actually the management company probably really wants, because they don't want to inadvertently take on the regulatory responsibility and the liability that goes with it. And also as part of that, the owner needs to retain the ability to even oversee the functions that have been delegated, whether if it's maintenance functions, then they need to specify in the agreement, and they should take an active role. Anytime the plane's in the shop, obtain those maintenance records so that for future flights, if the owner's the pilot or if they have used contract pilots, the pilots can go through the maintenance record, determine that the aircraft is fit to fly, because the operator, even if it's delegated its maintenance functions, is still responsible to operate an airworthy aircraft. That liability rests solely with the operator. Other examples would be you can delegate out providing the crew, the training for the crew, flight planning. So it all depends on the sophistication of the particular owner-operator. Again, a very important issue with crew is where is the where the crew come from and who they answer to. A question we like to pose to some of our clients when this issue comes up is, if the FAA ramps checks your flight and asks the crew, who do you work for, what's their answer? Anybody? Anybody have a good answer? FAA is not allowed to answer yet. Anybody? The common issue is, well, if you're using contract pilots, they're asked, well, who do they work for? Well, I work for Reynolds Jet, which may be technically true. In a W-2 sense, they work for Reynolds Jet. But if you've contracted those pilots, they need to be your agents. And I think the ideal answer is, I work for Reynolds Jet, or I'm employed for Reynolds Jet, but I'm an agent for Jason Maddux on this flight, and I'm under his exclusive direction and control. That'd be the ideal response. The way to address that, not only you can have it in the management agreement or a separate crew agency agreement where each pilot signs, acknowledges when they're flying for me, I'm the operator, I have operational control, and under my direction and control, even if they are employed by a management company or crew resource company and receive their paychecks from that other entity. So the other considerations and pitfalls, we've gone through some of these. The first is, as Aaron mentioned, even for 91 operators, it's recommended to have your own manual that specifies how you retain operational control, but also how you want to operate the aircraft. Because if you obtain, say, contract pilots or contract maintenance, then those functions you've outsourced to whomever, they have a source to look back at and say, oh, well, this is how this operator wants to conduct his or her flights. This is how the maintenance is to be provided. It can include, crewed flight and duty times if you want to have those. What weather minimums are acceptable for releasing the aircraft, any kind of operational factors like that. Who's authorized to perform the maintenance, whether you just a traditional A&P mechanic, or if you want a full Part 145 maintenance facility to do it, and even what the minimum pilot qualifications you are willing to accept. It's usually what your insurance company is willing to accept, but those can all be set out in the manual, so you do have a written resource that can be provided to these external entities that you delegate functions to. Again, the functions that are delegated, not the operational control responsibility. That cannot be transferable. Where this has been addressed a little more recently in the regulations is in the context of the fractional ownership regulations, where in 91-113, the fractional manager, when it's bringing on a new fractional interest owner, is required to brief that new owner on operational control responsibilities, and the owner is required to sign an acknowledgement of that. It's usually a one-page document, and it usually follows exactly what's set out in the rules. But I often wonder if the owners read it carefully, because it does say that they will be responsible for compliance with the fractional manager's management specifications. And I wonder if those are ever reviewed, if they understand what that entails. It also says that if there's any violations of those for the owner flights, that enforcement actions for that noncompliance could fall to the owner. And they have liability for personal injury and property damage. Of course, I'll let the litigation attorneys really determine that in litigation, but that is one of the elements that are required by the owner to be signed and acknowledged. The other two-sided provisions there, also in the fractional ownership rules, one has states the owner's operational control is responsible for the safe operations and complying with the fractional regulations, though it may delegate some of those functions to the fractional manager. But even though the functions are delegated, the responsibility is not delegated. And 91-1009 states that it's because that owner has operational control, it's the one directing the fractional manager to carry passengers and cargo on these flights. So again, it's confirming an operational control element. I think as Aaron mentioned, transfers of possession of the aircraft, that's a key element of operational control, who has possession. They must be legal and effective. I mean, they can take several forms of lease, dry lease, for instance, rental agreements. Say if I go to my local flight school where I did my training and I want to rent the plane, I have a rental agreement that transfers possessory interest to me, so I have operational control. Sometimes it's a license. These take various forms. If it is a lease, as I mentioned, there is the truth in leasing requirements in the FAA and the FARs. One is that it be in writing. It has to state who will have operational control, or who will exercise the functions of having operational control, how the aircraft was maintained over the last 12 years, where a list of the factors that go into operational control can be obtained, which is the local FAA office. The copy of the lease has to be carried on the plane while it's operating under the lease. The lease has to be filed, though not recorded, with the FAA Civil Aviation Registry, the technical branch in Oklahoma City, within 24 hours of its execution. And before the first flight, at least 48 hours before the first flight, notice has to be given to the local FAA office closest to where the first flight will operate that this aircraft will operate pursuant to this lease. So there are some hoops to jump through to make sure that the transfer of possession is both legal and effective. And I think we've gone through the issues with liability and how there can be confusion, especially in the 91 cents and when there's a manager involved, which we'll get to next. Okay. Just want to jump to the practical examples because we'll get there. One of the practical examples we have, which is essentially this operation, where you have, as Aaron mentioned, a migration. You have an owner who wants to operate Part 91, but he wants to place his or her aircraft with a 135 operator who will charter it out to third parties, and there will be a share of the revenue. It's ideal to defer some of the cost of owning and operating the aircraft. The problem is these migrations between 91 and 135 cause operational control confusion. Again, that can be mitigated with management agreements, with crew resource, or crew agency agreements that delineate who has operational control and when. In this specific instance, we always recommend there needs to be a written record of who has operational control and when is it leaving the 135 operators control and going to the 91 operators control. That can be done by logbook entry, it can be done by exchange of email, whatever written record you want to have, but we definitely recommend that if FAA should ever come knocking. There we go. So they have the 4 different types of flights in this scenario. 91 owner flights, we talked about 135 owner flights. Aaron mentioned that if the owner elects to operate everything, have the 135 operator operate all the owner's flights under 135. That's perfectly fine. There's, of course, tax and liability issues for both parties to consider. There's the 91 operations of the 135 operator themselves. Aaron mentioned them. They're found in OPSPEC 0A001. Crew training, maintenance tests, fairing, repositioning, carriage of company officials, which are all fine, provided no compensation is received. And then 135 charter company flights is your typical charters to a third party. When everything's operated under 135, there's no migration. Confusion goes away, hopefully. The 135 operator knows who has operational control. There's no distinctions made if the owner of the aircraft's on board or not. Everything's under the charter carriers, FAA, and DOT authority. They have all liability and responsibility. Now we'll get into the practical examples.
So we thought it might be useful to talk quickly about a few practical examples just to wrap up. And the first one is the simplest one, and Al alluded to my airplane, or the one I'm involved in, and that's it, by the way. If you go on the FAA aircraft registry and search under November 29552, you'll find that airplane is owned by an LLC, and it's called Montgomery Skyhawk LLC. And that, the reason we've structured it that way, I have 3 partners in the airplane. There are 4 of us that own and operate this aircraft. And we each own a 25% interest in the LLC. And we structured it that way so that if someone wants to sell their interest, it's easier to do so, to transfer an interest in an LLC rather than have 4 registered joint owners to an aircraft, which involves a much more complicated re-registration and so forth that we don't need to do. But, and by the way, this is just one way to do this, a simple illustration. It's not the only way. It's not necessarily the best way, but it's what we've done. The aircraft is never operated by the LLC. If it were, since we're all funding the LLC to pay for our maintenance and our tie down and all of those sorts of things, we'd all be in violation. It is operated by the individual pilots. So what we've provided in our LLC operating agreement is that if I go out to fly the airplane, we maintain a log in there. I enter my name in the log. I enter the tack time that I'm starting. I fly the airplane for an hour or 2, whatever it may be. I come back. I enter the tack time at the end. And that, under our agreement, indicates that I was in possession, that the aircraft is in my exclusive possession during that period that I operated it. The next day or the next week or whatever, somebody else does the same thing. So what we've done is we've established a written record between the terms of the LLC operating agreement and our aircraft log that this individual pilot had possession of the airplane during that period and had operational control of it, was in operation of it. Now, that's a very simple illustration, but you could do the same thing. You could take the same thing and apply it to a much more sophisticated airplane than a Bug Smasher 172. The way it could be done is, again, you'd have the aircraft owned by the LLC, but under your agreement, when one of the owners of the LLC wants to fly somewhere, that owner is deemed in operational control. And then that owner retains pilot services under an agreement with 1 or more pilots who have acknowledged in the agreement that the respective owner who's hired their services has operational control, that that's who they're answering to. And then, of course, before that airplane moves, this is all covered by an appropriate level of insurance, with the pilots listed as necessary, as authorized pilots, and the LLC and all of the individuals covered by the insurance. To the extent any LOAs are required, each of the owners, each of those individuals that will have operational control has an LOA issued in their name. That's how that type of an arrangement can be structured and comply with the operational control requirements. Second one I just touch on very briefly, pilot-owned aircraft. So what I'm talking about there is where you have a situation where you have an individual who owns a company and also separately owns an airplane and operates the airplane on for his or her business purposes. And there's a caveat here, really, and the caveat is don't make the assumption that business would never be found in operational control. It's possible the business would be found in operational control. As I mentioned at the outset, the concept of operational control is very broad, and there are some FAA enforcement cases that establish or at least strongly suggest that operational control could be construed broadly enough that even though the business on the face of it has nothing to do with that airplane, the business might be construed to be in operational control of those flights. So that's a situation where that individual's use of that aircraft for his or her business purposes, again, should be documented carefully between the individual and the company to establish who does have operational control, so that the extent the issue ever comes up, it's already been addressed. Jason, you want to take the other three?
First, the last three, the contract pilot operations, much like the prior example. If I go out and hire a contract pilot to fly my jet, should not actually assume that I'm in operational control. That would seem logical, and this will go out to all the contract pilots, and if any in the audience. There is an FAA interpretation directly on point that warns the contract pilots that you could be found in operational control in this scenario. So it's recommended, again, that there be a written documentation, some kind of crew agency agreement saying when you as the contract pilot are flying for me, I have operational control, and not vice versa. Again, it's the concern about shifting liability and responsibility. I'll skip the Darby Platinum Jet for a moment. Typical charter management scenario, that's what we're talking about when the plane migrates between 91 and 135 for owner flights and charter or third-party charters, and the owner receives the aircraft's on the charter's certificate or op specs and receives one or more functions, operational control functions provided by that management company or the 135 operator. Going back to Darby Platinum Jet, that's actually the Teterboro crash that Aaron mentioned at the outset. Darby was the 135 certificate holder. Platinum Jet was the aircraft owner, actually owned several Challengers and leased them to Darby to place on Darby's op specs. And going on the into TSB appeal decision, basically it read like a litany of don'ts in the operational control context. The FAA alleged that Platinum Jet, again, was not the air carrier. Platinum Jet provided the aircraft. Platinum Jet maintained the aircraft. Platinum provided and paid for its own maintenance personnel. They prepared and kept maintenance records. They employed and dispatched the flight crew, including the pilots and flight attendants. They scheduled the pilots and flight attendant training and maintained pilot and flight attendant training records. Platinum conducted the pre-employment and random drug testing, prepared and submitted the TSA criminal history records checks for the pilots and mechanics, provided scheduling, including any of the charters, even the 135 charters, and they prepared and kept records of each trip itinerary and flight manifests on their own letterhead, the report adds. And in exchange, Platinum paid Darby a certificate, what they called in the agreement, this was all in a management agreement, what they called a Part 135 certificate fee. I don't know what you would call a rent certificate fee, but that sounds like it. And also, Platinum received 90% of all charter revenue, with Darby receiving only 10%. And these were for charters arranged by Platinum. In theory, Darby could have arranged its own charter, held out and sold its own charters on the plane and operate those charters, but it actually never did in reality. So with all that, again, that runs the gamut of all the operational control functions it seems like you could have. And they were all being conducted by an entity that did not have operational control or should not have had operational control of the aircraft because they were not a licensed FAA air carrier. Now, as we've talked about today, some of these functions can be delegated, and the functions can be delegated to other entities, and the person delegating or the entity delegating those functions can retain operational control, but that requires some oversight on that person's part. And in this particular instance, Darby did not maintain any of that oversight. As Aaron mentioned, the particular aircraft that crashed, they didn't even know it was going to fly that day. And as the NTSB report shows, they did not maintain any of the records. Platinum had all the records. They didn't know if these pilots were qualified. They didn't know if the airplanes were airworthy. They didn't know when they were dispatched. So basically they had not only delegated functions, but they had delegated all operational control to Platinum Jet. Actually, what I was surprised was not in the report, and I thought I recalled this from the time, and Aaron, correct me if my memory is false, but I recall Platinum Jet, the use of business names being in A00 as well was because Platinum Jet was holding itself out as Alpha Jet, which was a registered DBA of the Part 135 operator. Now, not holding itself out as agent for Alpha Jet or DBA or Darby DBA Alpha Jet, but as Alpha Jet. So it was holding itself out as a direct air carrier. And not only did Darby get in trouble with FAA, they had a emergency certificate suspension, which was lifted eventually. But the DOT went after both Darby and Platinum Jet under DOT's authority, economic authority. They got Platinum Jet for holding itself out as a direct air carrier, which it was not registered with the Department of Transportation as an air taxi. So Platinum Jet was assessed it was a $125,000 civil penalty, and two of its principals were assessed jointly and severally a penalty of $25,000. And DOT went after Darby as well for facilitating Platinum Jet's holding out itself as a direct air carrier when it did not have authority. And Darby was assessed a $60,000 civil penalty for that. So again, that goes more towards the regulatory liability when you have operational control or when you shouldn't have operational control. And I think we might have left time for questions. Otherwise, we can answer questions at the question session later this afternoon. Al? Please.
Responsibility, growing concern of how accountable FAA look at liability. 35 aircraft.
I individually haven't seen that come up. Have you?
No, and I would say the answer to that question is a firm maybe.
All right, it depends.
No, I mean, seriously.
Well, and you asked the right question. You asked regulatory liability. I mean, in the civil liability context, everybody's going to get sued. That's why you have insurance. That's what's going to happen.
Yeah,
but regulatory is a little more gray. Right?
To me, civil liability would be a greater concern in that scenario. Because if you talk about a civil trial with a jury and talented trial lawyers, putting forth the case and saying, oh my gosh, this terrible accident ensued and XYZ Air Taxi knew about it and did nothing to prevent it, and they're the experts, and how could this happen? And that was negligent on the part of the air taxi, even though they didn't have operational control. I could see a jury being persuaded of that. I think, that's not my bailiwick, but I think it could happen. On the FAA side, I'm not sure exactly what regulation the FAA would bring that under. 9113, careless and reckless, but that has to do with the operation of an aircraft. So for a 9113 violation to be established, you'd have to establish that the air taxi that's being charged was operating the aircraft, which would be contrary to all of the operational control criteria that the FAA itself has set. So that seems to me to be a lesser concern. That's my take on it. These cases, operational control cases from the standpoint of FAA enforcement, they're not that common. The FAA is, I'm not trying to suggest that they're out there investigating 91 operators or 135 operators day by day, trying to figure out if there are operational control violations. They have more pressing matters to attend to. But they do come up sometimes, and they would come up most typically if there's an accident or incident or something else that draws the FAA's attention to it. And of course, that's where things could really get ugly. Just this week, this week, the FAA put out a press release that, no, that's not it. Put out a press release announcing they're seeking a $154,000 civil penalty against 3 companies and 1 individual in Utah for unlawful commercial operations. And this is a perfect example of what I'm talking about, what some people refer to as Part 134.5, okay, where you've got a 91 operation, but it's functioning essentially as a commercial operation, selling its services. What led to the FAA getting wind of this, I don't know. It might have been a complaint submitted by a 135 operator. It could have arisen under a number of circumstances, but when they find out about it, they take action. And so I think, it is something to be concerned about and to pay attention to. As I mentioned, after the Teterboro accident 10 years ago, the FAA got very concerned about it. They did special emphasis inspections, and they've drawn back somewhat from that. There has not been any further special emphasis inspections, but it is something they pay attention to. So our recommendation certainly is that this is something that all of you should pay attention to.
And in that Darby example, one thing we didn't mention is there was plenty of liability responsibility to go around, including with the FAA, not to let the FAA off the hook too easily. The Darby's own FSDO had approved that management agreement with Platinum Jet. But as the NTSB pointed out, just because the FSDO took a position doesn't mean the administrator, meaning the FAA administrator headquarters, couldn't take a different position, which kind of leaves the industry in a very tenuous position. But again, to give FAA credit, since then, not only have they emphasized this issue with the industry, they've emphasized it with their own inspectors on the elements to look for and what is and is not permissible as far as operational control and the transfer of functions, where that lies.
Okay. Thanks very much for your attention. Al?